will introduce Director Jerry Bruce. Jerry has been a parent attorney, guardian ad litem, prosecuting attorney, delinquency, and adult defender, also a special assistant attorney general representing DFACS, and also a juvenile court judge. Essentially every job an attorney can do in Georgia's juvenile courts. He led the Georgia Supreme Court Court Improvement Program for 5 years. And in June of 2021, he was appointed by Governor Brian Kemp to be Georgia's child advocate, leading the Office of Child Advocate for the Protection of Children. He is also an adjunct professor at Emory University School of Law, co-lead faculty for Georgia's MD Multidisciplinary Child Abuse and Neglect Institute, and is co-author of Georgia's The Guardian Ad Litem Independency Proceedings, a guide to best interest advocacy. He regularly writes, speaks, and trains on child welfare issues in Georgia and nationally. And it's a privilege and honor to welcome Jerry today and look forward to his presentation. Thank you very much, Jerry.
Sure. If you have been, are y'all seeing the slide or the presenter view? I want to make sure I've got it up right.
This slide, Jerry.
Okay, cool. So this presentation arose out of our Multidisciplinary Child Abuse and Neglect Institute. So I don't think a lot of people have been to a part 2 of that, but if you have, you've seen a version of this. All of the issues that we have raised and all the issues that are addressed in this presentation are issues that have actually shown up again and again in jurisdictions where either we've done MD Cannies or we've done court observations. Some of these were things that I was personally involved in and saw. Some of these things are things that I came across as the result of an investigation in the Office of the Child Advocate. So a lot of these things are kind of hypotheticals, and they're designed to be like, you know, kind of a live discussion with an in-person audience. Without that option, I guess probably the best thing is for me just to put these up and then discuss them. If you'd like to add comments in the chat, I can try to look at those as we go as well. But it'll be a little different perhaps than it would be if we were in person. So it's really important to talk about the role of the lawyer in our child welfare proceedings, because we're seeing a lot of confusion across the state about exactly what the lawyer is supposed to do. The SAG seems pretty clear on what the SAG's role is in most of the jurisdictions that I'm familiar with. And having been a SAG, it's easy to do because your job is pretty clear. You represent DFACS and you do your best to advocate for the wishes and direction of your client. Parent attorneys are a little more clear, but we still have some difficulties with parent attorneys not understanding their role as well. And we have a lot of difficulty with child's attorneys and attorneys guardian ad litem or CASAs advocating for the best interest of kids. Less so with CASAs than with attorneys guardian ad litem. So we want to really think about what it means first. We want to zero in on child representation, although this will touch on issues related to parent representation as well. But we really want everybody to think about a little bit about child representation. Even if you don't represent children, thinking about this can help you understand what you need to prepare for, defend against, how you can assist or otherwise, react for or against the positions of the child's attorney or a guardian ad litem. So what does it mean to be a lawyer for a child? How different is it from representing an adult? Do the model rules of professional responsibility apply? Is professionalism the same? Is it enough to comply with basic minimum rules when you're dealing with child representation? Or is there something more required in order to really properly fulfill that role? I think you'll see as we talk a lot about representing children that much of what we talk about is actually easily analogized to the situation of representing an adult with an impairment. And if you've ever represented an adult or dealt with an adult in juvenile court, you know that many, if not most, of the adults that we're dealing with as parents, really in our dependency cases, have some kind of impairment as well. They're suffering from substance abuse or use disorder. Many times that's masking a previously undiagnosed mental health issue. And so we often just assume that the parents who appear in juvenile court cases, dependency cases, are just normal functioning adults, when in fact, that's often not the case as well. And there are special considerations to be taken into consideration for that as well. So we'll be looking at some of the rules. We'll be looking at the scope of representation, communication, confidentiality, diminished capacity, the appropriate advisor role, and candor towards the tribunal. Also, we're touching obviously on competence and diligence, conflicts of interest as well, but we're really just going to focus on these roles and rules. So I give this presentation to a multidisciplinary audience a lot. It's really interesting to get the answers to what they think to these questions. If this is, I think, an entirely attorney audience, so you're aware that the lawyer decides, well, the client decides on the strategy of the case. Where are we going? What is the ultimate goal of the case? The lawyer assists the client in making that decision, but once that decision is made, the lawyer abides by it. The lawyer engages in the tactical considerations. So the client says where to go, the lawyer decides how best to get there. And when you disagree with the client, we're going to be talking about that a little bit later. One of those issues that falls within the purview of the client, it's appropriate to attempt to counsel the client, to attempt to provide your expertise and life experience to the client to inform the client's decision-making. But in the end, you're abiding by the client's wishes and desires on those things that are within the client's sole responsibility. When it comes down to how to conduct the hearing, what kind of witnesses to call, what kind of motions to bring, things like that, then of course you're going to be communicating with your client and keeping the client in the loop so the client understands what you're doing and why, but you're making those decisions. And if you and the client have a disagreement, then it's up to the lawyer to attempt to resolve that disagreement short of withdrawal, if that's what it comes to in the end. And this is true when clients have bad judgment and when they when they ask you to do things that you don't really want to do or that you would not like to do yourself. And we're going to look at some of those issues as we go forward as well. I seem to have lost the ability to make my slide go forward. So I'm totally disenchanted with Zoom meetings now. So after 2 or 3 years of them, scope of representation is clear to you all. The lawyer has to abide by the client's decisions concerning the objectives of representation. And that's true for the most part when a client is a child as well. And you got to keep in communication with your lawyer. You know that the most common complaints that lawyers get in terms of bar complaints, complaints to judges and others involve communication and lack of communication because clients feel that they're not properly kept in the loop. They don't know what's going on in cases. Lawyers are not communicating with them prior to hearings. They come to court and they feel unprepared for court because they're only meeting with their lawyer minutes before a hearing. Those are the kind of things that are really a great predictor of the probability of a bar complaint or some other type of disciplinary action. Just it's a basic requirement to keep your client in the loop, speak with your client, and consult with your client. We get complaints at the Office of the Child Advocate from children in foster care. So most of the time they're older children, but not always. And one of their most common complaints is not just that there's some issue with defects, but their most common complaints now to us are that their lawyers are not communicating with them and that they don't know what's going on and that court hearings are happening that they've not been informed about and that they've made no decisions about whether to be present or not. So we're going to talk about those things going forward. It's assumed that the information provided is that you would provide to any comprehending and responsible adult. However, the bar rules have an understanding that when you're dealing with an adult, perhaps with a disability, even if that disability is a temporary one caused by substance use or something like that, then those rules, their application may be a little bit different. Same when you're dealing with a child, depending on the child's age and level of development. Everybody who's dealt with children knows that you can't make a judgment about the capacity of a child client simply by looking at the child's age or even looking at the child on paper. There has to be a really intensive personal interaction with a client in order to determine where that client is on a spectrum of ability, comprehension, communication skills, and others. We've dealt with, all of us, probably with older teenagers who may have difficult times communicating clearly. They may have trauma backgrounds or other issues in development, or any other types of issues that may impact their ability to really help the attorney do his or her job. On the other hand, I've encountered children as young as 6 or 8 who are very clear about their goals in representation, what they want out of hearings, and who advocated for themselves very strongly, sometimes more effective. I recall specifically an 8-year-old in a case in Lumpkin County when I was a judge, who advocated for himself and his siblings much more effectively than his adult lawyer did for him and his siblings. So the only way you can know this, where your client falls on the spectrum, is through real intensive involvement with the client, by communicating with the client, talking to the client, getting to know the client, so you can make a determination about where the client falls in the spectrum of understanding and communication skills. 1511-103 is very clear that the child's attorney does not have a different set of rules. And the rules themselves note that while the attorney may be challenged in trying to provide a normal attorney-client relationship to a child, that relationship is still an attorney-client relationship. And that doesn't change because of the child's age. We'll talk later about what to do with a child who is not communicative at all because of age or other issues. But the attorney owes the child a normal attorney-client relationship with all the attendant duties and responsibilities of communication and following the direction of the client, even if that client is a child. I think we should go ahead and acknowledge that we have a real muddle in thinking about our dependency cases, particularly because they involve a child. There's a child, one or more children at the heart of those cases. And it makes us have sloppy thinking about those cases. It makes judges impatient sometimes with following the statutory rules that are designed to ensure that the decision-making process is objective and evidence-based. It makes attorneys sometimes uncomfortable in following the directions of their clients because those clients are children. It makes them unsure of their role. I was asked to come with Angela Tyner from Georgia CASA to a jurisdiction to talk by the judge, to talk to the child's attorneys, because he said, my child's attorneys are advocating for the best interests of the child. They're not advocating for what the child wants. And the only person who is in the courtroom who is advocating on the record specifically for statutory best interest is the guardian ad litem. All attorneys obviously are required to protect the interests of their clients. We all talk about the best interest of the child because we know that the court is required to consider the best interest of the child, and we had better be aware of what those requirements are for the court to find best interest so that we can overlay our arguments in light of those requirements in order to make informed arguments to the court. But only the guardian ad litem, whether that guardian ad litem is an attorney or a CASA, is actually advocating in court specifically for the best interest, the statutory best interest of their clients. And this makes a lot of us very uncomfortable. But in most cases, with adult and child clients, the best interest of the client are determined by the client's wishes and instructions. So we are required as child attorneys, when we are child attorneys, to abide by a client's decisions concerning scope of representation. That means in some cases we may have to spend a lot of time explaining the hearing, the purposes of the hearing, the purposes of the action to a child client in an age-appropriate way, and then abiding by that a client's wishes. We get really queasy about this in dependency cases, but anybody who's ever practiced criminal defense law is very familiar with this because, we know from experience in criminal defense law that despite your best, sometimes criminal defendants are in a sense very childlike in their approach to life and to seeking immediate gratification and things like that. And in my experience, communicating with a criminal defendant in some cases is like communicating with a child sometimes, depending on who that person is and why. Certainly there are very sophisticated and highly intelligent criminal defendants, but many of them operate on a sort of reward and punishment basis, similar to the way a child thinks about the world. And if you've practiced criminal defense law, you know that the fact that your client wants you to do something that you think is, stupid, does not deliver you from the responsibility of standing up in front of the court and advocating for that thing that you think is stupid. Obviously, you have a requirement to try and educate your client, to bring your client around. But as long as what your client is asking you to do is not in violation of the bar rules, your job is to get up there and advocate for that. And everybody should understand that. And no one should be shocked or surprised when you're advocating for what your child client wants, rather than what you think would be in that child's best interest. In fact, this very question came up in a formal advisory opinion in 2017 in response to the dual role of persons who are appointed as the attorney and as a guardian ad litem for a child in our dependency proceedings. And where that role is in conflict, the Georgia Supreme Court said that the child attorney role trumps. It's the one that wins in a conflict. If you're duly appointed and you have a conflict, you don't continue as the GAL because you've already had privileged communications and an attorney-client relationship with that person. So you continue as the attorney. And that means that the attorney's job is not to advocate for the child's best interests, but rather to follow the attorney-client relationship as closely as possible. And the Georgia Supreme Court looked at some other states where attorneys for children are allowed to have a hybrid role in their representation, and they explicitly rejected that hybrid role and said an attorney representing a child in a dependency case has got to follow the child's wishes and advocate for what the child wants. So what happens if you have a child who's incapable of communicating those wishes to you and those desires to you, either because of age or other developmental problem? Then we deal with the substituted judgment standard. But there's a common misperception here. The substituted judgment standard does not mean that because my client is 3, I substitute my judgment for what I think is best for the child, for the child's judgment. What it means is that I try in as much as I can to ascertain all the facts and circumstances of that child's life, the sense of attachments. It's almost like a sort of dive into the best interest factors, but instead of coming up with an objective evaluation of what would be in the child's best interest with those factors, it's objectifying for ourselves what we think that child would reasonably want if that child is able to communicate to us. Who's the child got a good relationship with? Why wouldn't the child want to be returned to the home? Is there any reason why that child would not want to be returned to the home? Not, do I think it's best for the child to be returned home, but under all the facts and circumstances I can ascertain, what would that child want if that child could make this decision known to me? That's the substituted judgment standard. It's not I'm substituting my judgment for that of the child. I'm seeking to ascertain what the child would desire if the child could make that statement to me clearly. So let's look at a communication hypothetical. So you're representing a young man, 15-year-old, who's in defects custody and who has a beneficial relationship with his parents, even though he's not in their custody. He's living with one aunt, but doesn't like living with her and would rather live with another aunt. You agree with him that option would be best for him. That would be a great one. And you believe that you could convince the judge to do what your child client wants and have the child placed with that aunt. But the department has informed you through the SAG that if your client doesn't consent to permanent guardianship with the aunt he doesn't want to go with, they're going to file a termination of parental rights, despite the fact that he has a beneficial relationship with his parents. This is an actual hypothetical that occurred in a real case. And the question that came up was the lawyer wondering, well, whether I tell my client this, because if I tell him this, he may make the wrong decision. And I want to protect him from making a wrong decision. So the question is, do you tell your client about this issue? He's 15 years old. And the answer is clearly yes, you have to. You can't try and protect your client from bad decision-making by withholding information from your client. The way you attempt to help a client overcome bad decision making is through your role as a counselor and an advisor. You do your best. If you can't get them to follow your advice, then you advocate for the thing they want, even if you think that might involve bad decision making. So that's a pretty clear one to start with. So let's look at communications, confidences, and secrets. I think you're all probably aware of the difference between a privilege and a confidence under Georgia law. Just to cut this, if we were present, we talked about this and ask you to give me examples of each, but we can't really do that. So just in short, a privilege is a relationship that is protected by law to the greatest extent possible. And normally, privileged communications are not accessible to outside parties through the use even of compelling court proceedings like a subpoena or a court order. So the stereotypical privileged communications that we deal with on a day-to-day basis are the attorney-client communication. It's not just confidential. It is confidential, but it's also privileged, which means that in most cases, the attorney can't reveal the contents of those communications except under very limited circumstances. Whereas confidential communications, such as doctor-patient communications, can be disclosed pursuant to a subpoena or a court order. So the lawyer has to be aware of the fact that what the child client or an impaired adult client tells the lawyer is privileged, and the lawyer is not able to communicate that. The only real exceptions are that the lawyer can reveal information as necessary to avoid harm or loss, financial loss to another as a result of criminal conduct by a client or by a third party known to the client or under the control of the client, or to prevent any type of serious injury or death not covered by this. The sort of classical example is that your client tells you that because your client is unhappy with the way the judge ruled, that the client or someone at the direction of the client is going to assassinate the judge when the judge leaves the parking lot. That has got to be disclosed because the disclosure of that is necessary to prevent harm or significant financial loss, but only so much information as is necessary to stop that thing from happening can be disclosed. It's not a blanket waiver of the attorney-client privilege either. It's got to be extremely narrowly tailored to the stopping the bad and unintended result. So let's look at a confidentially hypothetical, because in my experience, a lot of attorneys for children have difficulty understanding that they have a duty of confidentiality. I sat in court in a jurisdiction in December and watched an attorney for a child who was the child attorney in every case on the calendar that day. He was the contract child attorney, reveal things that his client had told him. His client was not present in court. Presence was not waived. We'll talk about that later. It was pretty clear that that attorney had not communicated with this child client about what was going to happen that day. And the attorney not only revealed things that his client had told him, but then used that revelation in order to undermine the credibility of his client so that he could argue against what his client wanted. It was a clear violation of all the rules of the professional responsibility, a violation of the juvenile code's provisions for how attorneys are to conduct themselves. And it grew out of a confusion that this was a child and the attorney didn't believe that he was bound by following the wishes of a child. And the child in this case was a teenage girl who was perfectly capable of sharing her information with her CASA and who was perfectly capable of making her wishes known. And her wishes, he disagreed with them, but they were not per se unreasonable wishes. So you're representing a young man in a dependency proceeding, and he is living with an aunt. He's very close to the aunt. He's been in many placements, and this is his first real stable placement in a long time. He seems to be flourishing. And because you're a good lawyer, you meet with Charles prior to court. He wants to meet at McDonald's, and somehow by some miracle, DFACS agrees to this. They allow him to be transported to McDonald's. He comes in to meet you, and he has a black eye. And he tells you during your meeting with him that he got this black eye from his aunt's new boyfriend, who hits him with some regularity, sometimes sells drugs from the house. But he says, look, I don't want a placement change. I'm 16. I can handle this. I don't want you to take any action based on what I've told you today. So the first question is, can you tell anyone just about Charles's black eye? And the answer to that is yes, you can, because the fact that Charles has a black eye is apparent to anyone who is present and who sees Charles. It's not something that you have learned just because of your role as Charles's lawyer. The things that are visible to anyone and that are patently apparent to anyone are not the type of things that are subject to client confidentiality and privilege. It's those things that you learn solely because of your role of trust with the client. And so the black eye is itself not something that you had to keep quiet. You could call DFAC's worker and you could say, look, my client has showed up with a black eye. What's going on? I'd like to know what's happening there. But as far as a report goes, there's a lot of confusion. Attorneys are not mandated reporters. I've had attorneys in MD Canny after MD Canny say, yes, because I'm a mandated reporter. Attorneys are not mandated reporters in Georgia, certainly not regarding things told them by their own clients. So the general rule is that you cannot make a report to anyone about based on the specifics that Charles has revealed to you, other than the fact that he has the black eye. If, however, Charles showed up with a friend, and while Charles was ordering, the friend tells you, hey, listen, this is going on, and I feel like Charles is in danger, it's a bad situation. Then, of course, you're required to communicate all this to your client, but that communication is not privileged or confidential in any way. You have no confidential relationship with third parties outside the attorney-client relationship regarding these types of communications. So there was a question on the chat about, would this be true even if this attorney was also the guardian ad litem? And it's clear that that would, if you believed that that communication from your client created a situation in which his wishes were contrary to what you believed were his best interests based on a consideration of the best interest factors, then of course you would immediately have a conflict and you would have to step away as the guardian ad litem and continue as Charles's attorney and continue to abide by his directions. There's no circumstance in which the requirements of a guardian ad litem outweigh those of the attorney, which is why the Supreme Court has said that when a conflict arises, you stop acting as the GAL, you continue acting as the attorney. If the conflict is so bad that you can't continue acting as the attorney, then you get out of the case completely. But at no time do you countermand your client's directions regarding things that were revealed to you in the attorney-client relationship. Somebody's posted that DFACs lists attorneys and judges as mandated reporters. DFACs can say what they want, but the statute, the mandated reporter statute, does not list attorneys as mandated reporters for this very reason. Attorneys learn things in the context of their job to receive privileged communications, and except for that one very narrow exception, that if you believe it's necessary to make a revelation to prevent loss of life, serious harm, or serious financial loss, then you may do that. That's a call for the attorney to make on a fact-specific basis, and that revelation has to be extremely narrow, so narrow, as narrow as possible, just to prevent the harm from occurring, but yet without being a blanket dissolution of the duty to keep client confidences. So attorneys are not mandated reporters. So what happens if you're meeting with Charles the day before court to get ready for court? Because of course attorneys don't really get well prepared for court when they only talk to their clients immediately before the hearing starts. And Charles tells you there's no friend present. Charles tells you all this stuff, tells you not to tell anyone, not to reveal what he's told you. And you go to court the next day and the judge says, hey, Charles, I see you have a black eye. What happened? And Charles says, oh, Judge, I got into a fight at school. What do you do there? We've had some folks who say, well, you know, I tell the judge immediately that that my client is lying to him, or that something is going on that shouldn't be going on, And actually, the appropriate action to take in this is not to tell the judge what your client has told you, because the judge's request for information from your client does not create a waiver of the attorney-client privilege for you as the lawyer. What you can do in your role as advisor and counselor to Charles is ask the court for a minute to talk to your client. That will have the practical effect of allowing the court to know that something's going on without letting the court know exactly what is going on. And at that point, to counsel your client regarding his duty of candor to the tribunal. So that's important. This is not sworn testimony, so he's not really perjuring himself, but it's certainly possible to let Charles know that this is a practice that could wind up getting him into trouble. At the very least, it could cause the court to begin to doubt his credibility and to be less inclined to do the things that Charles wants done by the court. So there's a lot of things you can do to help Charles in this situation, but among those things is not to stand up and say, "Judge, my client's lying," which is actually something that we've seen in court before, and doesn't work that way. Yeah, Nissa says, counsel your client about truthfulness and veracity to the court. Come back in and see if things go better the next time. So let's move on to another. This is actually this is from a real case. So you're a guardian ad litem this time. Doesn't matter whether you're the CASA guardian ad litem or an attorney guardian ad litem, but you're the guardian ad litem. And the allegation in this case is your 3-year-old, the 3-year-old child in this case has been severely injured. Those are unexplained injuries. Dan, the father, is believed to have caused these injuries because they happened when he was alone at home with the child, and the mother, Dana, because, people who have names that sound alike love to get in relationships with one another. And I always say that I think that having names that sound just alike in a relationship is almost a statistical precursor to domestic violence. When you have names that are almost just alike, there's probably going to be domestic violence. So the allegation is that the father has caused severe unexplained injuries to Nicholas, and that the mother has attempted to cover up these acts. She's refused to make any statement to law enforcement or defects, because of course there's a marital privilege as well. So this is where we are. Unexplained injuries, not uncommon at all in defects cases. So in this case, because there's going to be a parallel criminal prosecution, there is a multidisciplinary task force meeting that has been convened by defects. And you, as a thoroughgoing attorney or CASA, being the guardian ad litem, attend this MDT meeting. And prior to going to the meeting, you meet with the mother as part of your duties to ascertain all the facts and circumstances of the case under 1511-105. You're talking to her in the hallway privately. And during the conversation, she says, "Yeah, Dan kicked Nicholas, the child, but it wasn't even that hard." And then during the MDT meeting, a law enforcement person who's present says, "Hey, I heard you just interviewed mom. Did she provide you any information that would be relevant to the criminal investigation?" And the answer to how you respond in almost a majority of the times I've asked this question to CASAs and attorney GALs is, "Oh yeah, I tell them exactly what was just said, because I'm not the attorney for Dana and I don't have a confidential or privileged relationship with Dana." The answer, however, is, as always, more nuanced than that. All information collected by the guardian ad litem is confidential and cannot be disclosed absent a court order. This gives a lot of people a lot of heartburn, because they think, "Well, I'm there to advocate for the child's best interest. I learned this information. We're at an MDT meeting. We're all supposed to be sharing information at MDT meetings." But the statute specifically says that if a guardian ad litem collects information in the context of the duties as the GAL, which is clearly what happened here. Dana's not talking to you because she's just wants to unburden herself to the first person she sees in the hallway. She's talking to you and telling you this because of your role as the guardian ad litem. While it is not privileged information, you can't share it outside what I call the sort of bubble of confidentiality that covers that case. The guardian ad litem is required to share information with the other parties in the case and with the court, subject to having provided that to the other parties so that it's not an ex parte communication. So you can't tell law enforcement. There are ways to get around this, though, because law enforcement has a specific exception, a limited exception under Title 49 to access certain defects records when investigating a criminal action. They do not have direct access to information gathered by a guardian ad litem. You can tell DFACS what Dana has told you, and there's no violation. DFACS can then reveal that to law enforcement if they feel like that's what they want to do. If law enforcement or anyone outside the context of a party of the ongoing case in juvenile court wants information from the GAL, whether it's GAL records or testimony, we learned from the JN case in 2018 that the only way to get that information is to have the requesting court issue a subpoena and then do an in-camera inspection before making any release to determine whether any non-privileged information is material enough to the party's case as to outweigh a policy that the GAL's confidential information not be disclosed. We have this a lot with CASAs, especially who do a thorough investigation in a dependency case and then get called as a witness in a Superior Court custody case that shares some of the same facts with the dependency case, where you have a non-offending parent, perhaps, who wound up with custody from DFACS. It's important for those folks to realize that they cannot share information without a specific authorization from the court that's requesting that. Usually in these cases, it's a Superior Court because it's either a custody case or a criminal case. And there has to be an in-camera inspection prior to the release of that information. So you can't give that information away. So you can repeat that to DFACS, and then DFACS can do what they feel is appropriate with it, giving it to law enforcement if necessary. But let's go back now and say that prior to the MDT meeting, you've actually gone to the bond hearing for Dan, and he was given a condition of no contact with Dana. So you've got that filed away in your head and in your file. And then the night before the MDT meeting, you're at a restaurant. And while you are there, you see Dan and Dana together in the restaurant. When you meet the law enforcement personnel at the MDT meeting the next day, can you disclose that information to law enforcement? And the answer to that is yes, you can, because that information, neither the facts ascertained at the bond hearing, which is a public hearing that creates a public record of a bond and its conditions, or the fact that they were together in violation of that in a public location, are things that wouldn't be accessible to any member of the public using normal means to find that information out. So that's not information that you've learned solely because of your role as the guardian ad litem in the case. So you could say, yeah, I saw them together at the restaurant last night in violation of the bond condition. So communication, very important to keep in mind. So when you have a client with diminished capacity, whether that diminished capacity is age-related and developmentally related, or whether it's an adult with substance use or mental health disorder of some kind, the attorney has to, there's no shortcut here. The attorney has to do as much as possible to maintain a normal client-lawyer relationship with the client. And only when it is demonstrably impossible to maintain that can the attorney seek to prescind from a normal lawyer-client relationship. And then there are specific steps to take to reduce the risk of any kind to the client, whether it's physical, financial, possible adverse outcomes in the hearings, whatever, in order to take protective action for your client. That protective action includes the ability to consult with other people who have the ability to protect the client and to communicate with the client. That might be family members. And while you're not able to share privileged information, you can talk to other people, family members and others, about how best to communicate with your client, and how best to get the results that you want to get from the client. In some cases, it may be that, especially with adult clients, that you will have a client who is so incapable of assisting you that you will want a guardian ad litem appointed to represent the adult client. This is not a capta guardian ad litem seeking to argue for the statutory best interest of the child. This is a guardian ad litem who is simply there to communicate in the place of the client because the client is unable for some reason to communicate effectively on his or her own behalf. This happened once or twice when I was a juvenile court judge, and it became clear that a client, a parent in both cases, was simply, in one case, I think she was actually insane. And it became very clear during her testimony when she was called by her attorney to testify. How her attorney didn't know that his client was insane before he put her on the stand was clearly possible only because he had never talked to her before. She was completely divorced from reality. She had no idea who she was, what was going on. She told, it was a very interesting testimony. I mean, you could pull that transcript and it would make just amazingly interesting reading, but she was not in her right mind. And I immediately stopped the proceedings and I appointed a guardian ad litem to represent her. At that point, the lawyer's role doesn't change, but the person from whom the lawyer seeks that direction does. Under our rules, if there's a guardian ad litem because of a client's incapacity, again, this is not a child's guardian ad litem under CAPTA. This is a guardian ad litem for someone who has impaired capacity. Then in that case, the lawyer is taking most of the information and direction from the guardian ad litem rather than from the lawyer, than from the client. The guardian ad litem stands in the shoes of the client. As much as possible, the client is still kept in the loop with communications, but it's the guardian ad litem who's then communicating with the client about things, and you're taking direction as the lawyer from the guardian ad litem. If you believe that you have to seek the appointment of a guardian ad litem for a client, an adult client, or take any other protective action, then only so much information as is necessary to take that action is revealable. Because your client is insane does not mean that the things that your client has communicated to you are not privileged. So you can't go and reveal all that information to a judge if you're asking for the appointment of a guardian ad litem. You just have to say, basically, Judge, I have reason to believe that my client is not capable of appreciating what's going on or assisting me meaningfully in this proceeding, and I believe we need a guardian ad litem appointed to protect the interests of my client. We'll come back to this question of the guardian ad litem in just a moment for an adult client. But for now, it's important to remember that having a different opinion if a child has a different opinion than the lawyer or insists upon a course of action the lawyer considers unwise is not diminished capacity, right? The fact that your client, whether it's an adult or a child, wants you to do something you disagree with, that you don't think is best for the client, does not create a situation of diminished capacity by itself. The determination has to focus on the decision-making process according to the ABA model. That is my client capable of making intelligent and reasoned decisions in an age-appropriate manner, remembering that we shouldn't expect children to convey their decision-making information in the same way an adult does, nor to make the same kinds of decisions that an adult does. But because a child makes decisions in the way appropriate to a child at that age of development does not mean that the child has diminished capacity, and that's important to remember. All right, let's go back to the question of the capacity, the adult with diminished capacity, where you're representing the mother with a mild developmental disabilities. This is not a case maybe of her being insane, but just one where there's a request that your client stipulate. And in this case, you talk with your client and it is unclear to you, it is clear to you rather, that she can't comprehend the risks associated with the stipulation. She just wants her child back so badly that she's willing to stipulate in order to have the child sent home under a protective order. You believe that this might well be setting her up to fail, but it's not just that you disagree with her decision. You just don't think she understands the risks involved, including the use of this stipulation as potential evidence in a termination of parental rights proceeding. So in such a case, if after taking other protective action, you believe you could ask for the appointment of a guardian ad litem for your incapacitated party. I've had some judges and others say, look, juvenile court judges are courts of limited jurisdiction, and they do not have the ability to appoint a guardian ad litem for an incapacitated party. You have to go to probate court for that. But this was specifically addressed in the Civil Practice Act in 9/11/17, where any court who believes that there is an incompetent or other person who can't represent him or herself in an action before that court shall appoint a guardian ad litem for that person. And 9/11/17 is made applicable in all of our juvenile court proceedings via 1511-4 that says if there's no procedures inconsistent with it provided, then the court has to proceed in accordance with, in our case, Chapter 11 of Title IX. So we actually have a direct route to the Civil Practice Act that empowers any court, not just empowers, requires a court to appoint a guardian ad litem to protect a litigant before that court who is unable to protect him or herself and to communicate effectively with an attorney. So let's look at another capacity question with that in mind. So sorry about the misspelling in this case, the typo. At an adjudication hearing, you're appointed to represent a mother in a dependency proceeding, and you get to the same position we just talked about. You don't think that she can help you. Maybe she's insane. Maybe there's other issues that are going on, but she cannot assist you. She doesn't understand what's going on. You say, look, I'm going to request a guardian ad litem. And she says, you're my lawyer, and I forbid you to ask for a guardian ad litem in my case. We just talked about what things are the client's purview and what things are the lawyer's purview. This falls right along that line in a normal attorney-client relationship. But in this case, if you believe that your client is unable properly to understand what's going on, you have an ethical duty to take protective action, which can include, according to the model rules, the appointment of a guardian ad litem. So if you believe that that's appropriate, then revealing only so much information as possible, even over a clear objection by your client and a clear direction to the contrary, you would still be required to seek the appointment of a guardian ad litem if you believed that that was the best thing for your client in that case. And then again, if the guardian ad litem is appointed, your role in the case now is to follow the direction of the guardian ad litem in speaking on behalf of the client. So one question that often comes up, if you have a guardian ad litem for a parent or other incapacitated person in a case, what's the extent of the guardian ad litem's powers and ability to act on behalf of the client? And unfortunately, in Georgia, we don't have a lot of ethical decision-making on this question. But for some reason, the state of Washington has had this come up again and again and again, and has some really compelling persuasive authority on this issue, and has looked at it in a number of cases regarding termination of parental rights, especially. So it looks like that the guardian ad litem could potentially waive a parent's presence at a court hearing, but could not waive representation by counsel, could not make a stipulation in a case, and could not surrender parental rights or consent to termination of parental rights. So there's sort of a spectrum of what constitutes fundamental rights, presence at a court hearing being a right, but not a fundamental right as long as there's representation. And in this case, you can't get an appropriate waiver from the client. So the GAL can provide that. But the basic due process protections and constitutional protections, such as representation by counsel, making stipulations that would change the outcomes of cases, and surrendering parental rights or terminating parental rights, consenting to those, are not, according to the Washington precedent, available to a guardian ad litem who's representing an incapacitated parent. So again, there are several considerations to take when representing a client with diminished capacity, and this includes sometimes our child clients as well, and those are an array of protective measures, starting with things like consulting with family members, using reconsideration periods, like with Charles in that case where Charles gave false information to a court, even though it was not under oath, asking for a minute to talk and to reconsider, or sometimes consulting with other professional services. In a lot of our cases, our clients, whether they're parents or children, have been the subject of clinical assessments and evaluations. And it's perfectly appropriate to contact the person who has done, the expert who has done a clinical assessment or evaluation, and say, look, I need some help in understanding how best to communicate with my client. They can be really an invaluable resource for that sort of thing. And at the high end, asking for the appointment of a guardian ad litem to protect them. And again, maintaining confidentiality and privilege as much as is possible. I really like the fact that our comments to this rule on the role of the attorney as an advisor not only encourage the attorney to give advice to the client, even if that seems to be unpopular, but also pointing out that simply giving purely technical legal advice can be inadequate, and that our clients, and especially clients with diminished capacity, and especially child clients, need more than purely technical legal advice. It's not enough just to quote the law to a child client. They've got to have an entire sort of ecosystem of information provided to them. And that requires a lot of time. It requires the establishment of a really robust attorney-client relationship, really an interpersonal relationship with especially a child client, in order to be able to give appropriate advice to that client and to enable that client in an informed way to make appropriate decisions. So we're going to wrap up in just a second. I think we're almost out of time. Let's talk about this candor to the tribunal one, because we touched on this from the client's point of view a little bit earlier. It's the attorney who has the duty of candor to the tribunal ultimately. And what that entails is a lawyer not making a false statement of material fact to a law or tribunal, failing to disclose a material fact that would avoid a criminal or fraudulent act. That's that whole "I'm going to kill the judge after court" thing. Failing to disclose that would be candor to the tribunal problem, would be an understatement about that, but it certainly is a candor to the tribunal problem. Failing to disclose legal authority that is adverse to you. This is something that a lot of lawyers struggle with, and straightforwardly offering evidence that the lawyer knows to be false without advising the court of that fact. So we often have a lot of lawyers who struggle with candor to the tribunal in certain areas. And this is a case that we actually had come up not too terribly long ago, like about a year and a half ago. So let's look at this one. You represent a 14-year-old girl, Maria, in defects custody. She's in a group home and she does not like it there because, well, it's a group home. So she calls you one day and tells you she's run away from her group home. She says, "Look, I think I have a great relationship with you. I trust you. I'm going to tell you where I can be reached." She tells you that she's with an adult relative. You're aware of this adult relative because this person's listed in the defects relative search. This person has been approved as a placement. It's not the placement of the child right now, not the court ordered placement. This child is in a group home still, but this is a person who has got no strikes against this person. And you actually speak to the relative and are assured after that conversation that Maria is in no danger. You don't get any other additional information from the relative about where Maria is or anything like that. All of that comes from her. She directs you now not to disclose her whereabouts to the court or to anybody else. Mainly, she's worried about defects. But because they're aware that you have a great relationship with her, the defects caseworker calls and says, "Hey, we're worried about her. We can't find her. What do you do?" And the answer is that you cannot tell the defects caseworker what your child client has told you in this case, unless you believed that it was necessary to protect her. And then only so much information as could be given. It was necessary to stop some harm from happening to her. In this case, you're convinced that she's in a safe place, if not a legal place, a licit place, a safe place. And so that probably would not apply in this case. And you could not tell the defects worker where she was. Of course, again, this would not be true if you learned all this from one of Maria's friends rather than Maria. But if you learned it directly from Maria, you couldn't tell her. So if the judge is concerned about this and calls an emergency hearing, or if defects asks for an emergency hearing because the child's missing, and the judge says, "Counsel, you know what's up? Have you heard from your client?" You may, of course, say, "Yes, Judge, I have heard from my client." If you desire to do that, the candor to the tribunal, I think, requires you to say that you have heard from your client. But if the court orders you to disclose Maria's whereabouts, you must decline to do so, given the facts in this hypothetical that you do not believe that she's in any danger and that no violation of the attorney-client privilege is necessary in order to prevent harm to her. You cannot tell the court. You just better have brought your toothbrush, because you may be spending the night in jail, but you cannot disclose your client's whereabouts. And we have attorneys, again, who struggle with this because they say, "Well, this is a child." Again, You're there to represent the child. In this hypothetical, you are not the guardian ad litem, you're the attorney. These are privileged communications and you can't disclose them. I just want to close with a consideration of a certain ethical dilemma that faces attorneys who are duly appointed as a child's attorney and the guardian ad litem. A couple of drawbacks to that. We know from the Court of Appeals decisions that there's no per se conflict in this dual role, and that if a conflict arises, we know from the Supreme Court opinion that the attorney has to step away as the GAL and continue as the lawyer as long as that can be done. But here's a question that has never been raised, and I think goes to the heart of this issue, and one I want you to think about. You're duly appointed as a child's attorney and guardian ad litem. You go to talk to her for the first time, and she asks you, is what I tell you confidential? Can you tell anybody the stuff I'm going to tell you right now? And the important question is, how do you answer her? Because the guardian ad litem, the communications with the child they're confidential as to parties outside the case, but they're not privileged. And in fact, ascertaining the child's wishes and desires and recapitulating those for the court is one of the ways that guardians ad litem deal with the best interest factors, one of which is the child's wishes, right? The guardian ad litem gathers information to share it with the other parties in the court. So the answer is yes. But the attorney cannot provide information to the parties in the court based on privileged communications between the attorney and the client. I think this is an unanswerable dilemma for attorneys who are appointed in this, because the only way to answer this question is to reject the guardian ad litem role. The only way to protect yourself as the lawyer, given that ruling from the Georgia Supreme Court, is to reject the guardian ad litem role, to adopt the role of the lawyer, and to say, yes, the things you tell me are confidential, they're privileged, I can't tell anybody, and to immediately ask to be removed as the guardian ad litem, because you've now made a statement that is acting upon that would make the guardian ad litem role impracticable. So that's really important. The child's communications, the child needs to know whether the communications are privileged or not. And I think the only way to do that is to not act as the guardian ad litem and only to act as the lawyer. Otherwise, you're opening yourself up. Either you're going to be ineffective as both the guardian ad litem and the child's attorney, or you're going to be in violation of the bar rules. And you don't want either of those things to happen. So I know that it's not possible in every jurisdiction, and probably in most jurisdictions, to avoid dual appointments. But I just want to really warn lawyers that this is a looming issue and it's never been properly decided. So if you want to help everybody, you could ask for an opinion from the Supreme Court on this issue. You could ask the bar for a ruling on this issue, because it'd be great to have some opinion to be able to cover yourself with if this issue ever arises. It also raises a procedural due process issue, because the guardian ad litem has to make a recommendation to the court. Very frequently, those guardian ad litem recommendations carry a lot of weight with the court. We see that in TPR appeal cases where it appears that the court really relies on what the guardian ad litem says. And because the guardian ad litem's recommendation carries a lot of weight in many cases, the parties have a right to cross-examine the guardian ad litem as to the factual basis for the guardian ad litem's recommendation. But you can't do that when that person is also the child's attorney. So the child's attorney, you can't call that person. You can't ask questions about, you can't call that person for cross and ask questions about what underlies the recommendation. So this is a person who now can give a recommendation basically without any ramifications or questioning by any party. It becomes impossible effectively to question the recommendation of a duly appointed attorney and guardian ad litem. So these are issues that I would love for y'all to raise so we can get some answers from these on these issues. And I'm sorry about the overlap there. But the main takeaways here are to remember that when you're representing, especially a child client, you got to treat that client as a regular attorney-client relationship, providing regular and sufficient communication, providing appropriate status updates, opportunities to make decisions, good advice on how to achieve the client's goals. Another big thing that we come up with again and again and again is remembering that the only person in the courtroom in a dependency case who can waive a child's presence in court at the next hearing or at any hearing is the child's attorney. The CASA cannot do that. The court cannot do that. The department cannot do that. The court can make a decision that a child who is present in court may need to be removed from certain portions of the court if the court makes specific findings of fact as to how portions of testimony could be harmful to a child. But that only involves the child's presence in the courtroom for a certain part of the hearing. It doesn't deal with the child's right as a party to be present, period. That's only waivable by the attorney for that child, and that determination has to be made in consultation with the client. Attorneys cannot waive their client's presence if their clients have not consented to that waiver unless there's some emergency or other impossibility. So perhaps it may be appropriate for a child who is 1 or 6 months old or something like that. But for the majority of the children that we see represented in our cases, it's going to involve a necessity of contacting your client, finding out if your client wants to be present, and making then a determination with your client whether you should waive the client's presence in court or not. And remembering that the child's attorney is not a best interest advocate. So fortunately, I don't think we have time for any questions, which is my favorite way to end a presentation. But I leave that to the organizers to make determinations about. And thank you so much for your time.
And Jerry, thank you very much for your presentation. And also thank you very much for your experience leadership in Georgia. I think through your years of involvement in this and your continued work, it strengthens the system as a whole. And that's really how we continue to move our child well-being system forward here in Georgia. So thank you very much. I will put Jerry's email address in the comments section, as we don't have sufficient time in order to be able to answer all of the questions that were posed today. For comments or questions specifically for Jerry, he's very accessible, so feel free to email him. And Jerry put it in there already. So thank you again, Jerry.
Sure.
Appreciate your presentation. At this time, I will turn it over to Jill Roth, who will then introduce our next speaker.
Thank you so much. It's always great to hear from Jerry. He always shares such helpful information. I previously introduced Dr. Sarah Vinson, who is the interim chair of the Department of Psychiatry and Behavioral Sciences at Morehouse School of Medicine. So without further ado, I will let her take the reins.
All right. And thank you all so much for your flexibility and grace with my scheduling problems today. And thank you for just moving things around. And hopefully this time is useful to all of you. And what I'll say at the beginning is that there's probably going to be very little of this that is new. It's just a matter of giving you all some time and some support and some structure and thinking through what it is you experience and its impact on you as a person, as an individual, as a member of a family, of a community, who is also someone doing work that, obviously you care about and are passionate about. And I got to hear just a little bit of the last presentation, and man, there's just so many ways you can get things wrong with such big implications if you do. And this is what you're dealing with day in, day out. And sometimes it can fade into the back a little bit. It can become background noise, but the tax on you personally is still very real and very much so there. So with that, we'll launch into this. And I do have a small private practice, and in that practice, see professionals, a lot of and many of them are in pretty high stress jobs. So I have clinical experience in thinking about these issues as well. So some ground rules. I do hope, and I realize it's probably a small community of you all, and you probably all know each other. And I know this is being recorded, but hopefully we're able to speak relatively freely here. and keep each other's comments in confidence to the extent that we can. I want to recognize that everyone has their own lens when it comes to this area and to the areas of their work that are most stressful for them, and just respecting other people's perspective. Please know that I'm happy to field questions throughout. I'll try to monitor the chat. I let Professor Waldman know if I missed something, just please, it's not an interruption, because I want to make this as relevant to you as possible. And in that vein, I certainly do not want to act as if I'm the expert on attorney well-being to a bunch of attorneys. You are the people who are doing the work day in, day out. So I really do welcome your comments and hope that this is a bidirectional exchange. So we'll talk a bit about child protection and advocacy attorneys and occupational risk, the mental health continuum, secondary traumatic stress, mitigating the risk. There's a survey that I'll ask you all to complete, and I actually put the link in the chat, and then I hopefully have some time for discussion. And so this is, obviously virtual. There are always a million things to do with a living document to-do list. And sometimes it can be easy to switch to a different window during any given talk. But what I would ask of you is to step back from the keyboard and from the mouse and to give, not me, but to give yourself this time to really be present as you're thinking about this topic. I know you wouldn't do this if you didn't love it and you weren't passionate about it. And I think there's parallels between your work and what we do in mental health, and that in order for it to be sustainable, we have to get this part right too. So emails will be there. To-do lists are living documents. Multitasking isn't a real thing. It's not. Your brain's just going attention one thing to another. So give yourself this time. And if you work 40 hours a week, and my guess is most of you work more than that, but if you work 40 hours a week, this is just 2.5% of your work week that I'm asking you to give toward completely thinking about this topic as it relates to you. So, obviously this talk is coming in at under an hour. This is a huge subject. When you're talking about mental health, it's so multifaceted. And, what I do as a psychiatrist, as is typically defined, is quite narrow, right? When you think about what makes people mentally healthy, what pushes people toward mental illness, so much of that, most of it really is beyond the realm of medicine. It's these social determinants of health. It's stressors, it's community factors, it's support networks, it's whether you're part of a marginalized identity group. So there are going to be nuances for this topic depending on where you fall in any number of things. And I just want to acknowledge that on the front end, and I can't get into the nitty gritty of some of those things given the time, but do want to make space for considering that. So there's what we have, right? Who we are and what we bring. And then there's the nature of your work and the decisions that you have to make, and what it means for you to be off one day and the ripple effects that can have, and that you're doing this really difficult work in the context of a society that is really grappling with a lot of things that impact children and families, and often quite adversely. And the group of children that you see, whether it's in welfare or in juvenile justice, are disproportionately impacted by societal policies, by the distribution of wealth and opportunity that is inequitable. And so not only are you trying to get everything right in your lane, so to speak, but so much of what you do, just as it is with mental health, has to do with decisions that are made upstream and at a societal level. And we know that we are just in very, very polarized times right now. And so with all that, right, with the work that you do and what you're up against, it's not surprising that there are going to be impacts of indirect trauma. And I found it interesting when I was looking up studies about this in attorneys, and they found that 2 studies found that lawyers showed more symptoms of indirect trauma than mental health professionals. And at first I was surprised, but then I actually wasn't, because as someone who does forensic consultation at times, the amount of records that you go through, the pictures that you see, the way you have to really immerse yourself in a case is different than it is for us, because we're usually just hearing about it. And so it's a different level of exposure that you have. And then you also may not have the supports that people in the mental health field have in terms of, supervision or the encouragement that we're in therapy as we go through training so that we can learn what it's like to be on the other side of the couch, so to speak. And so it's important to keep in mind that you are a high risk group. And hopefully it doesn't scare you, but if you start to notice that you're feeling some of these symptoms, that you don't feel like you're doing something wrong or there's something wrong with you as a person, but that there is in fact an occupational hazard of having symptoms of indirect trauma just because of the nature of what you do. The other thing I'll add is that when you look at studies of things like burnout or secondary traumatic stress, people who have more empathy are at higher risk for those outcomes. And so again, it's not a matter of you not caring or you being checked out. Sometimes it is that caring that actually makes this work more difficult. So considering how we define mental health, and it may sound like a really basic question, but so much of what we focus on in medicine and mental health and therapy and diagnosis is on illness, right? It's on symptoms, it's on what's wrong, it's am I depressed or not? Am I anxious or not? But in reality, everyone is on a continuum between mental health and mental illness. And the World Health Organization talks about mental health as a state of well-being in which everyone realizes his or her own potential, can cope adaptively with stress, is able to make a meaningful contribution to her or his community. And so that's our kind of North Star. But it's not really useful for us to think about health and illness as two dyads, right? It's helpful for us to think about it on a continuum, that it's not either or, and it's not diagnosis or not. And I can give you a whole other talk on the limitations of the DSM for really capturing what's happening with people and what's going on in their lives in a holistic way. And so if we think about this mental health, mental illness continuum, we have things that push us more toward health. So protective factors, supports, adaptive coping, and those supports may be natural supports or they may be professional supports, but we know natural supports are just as important, if not more so. And things that compromise health or that push you more toward perhaps illness, or maybe towards something that's not even a diagnosable mental health condition, but that is not that picture of mental well-being. So risk factors, stressors, and maladaptive coping. And the thing that I think we all gained more appreciation of as a society these past few years is how important it is to have a lot of coping factors at our disposal and that are accessible to us. What we saw during COVID was that the stress went up for everyone, right? But a lot of people's adaptive coping options were decreased. And in that setting, we saw as a population that people were doing more things that were not as adaptive, like using more alcohol, even eating more ice cream sales went up, and things like that. So for the survey, you'll see 3 outcomes when you do them, and we'll just see how we're doing on time, but you'll have the link whether we have the opportunity for you to go through it or not. But I would just ask you to go through these definitions and guess, educated guess, where you think you fall. So compassion satisfaction is about the pleasure you derive from being able to do your work well. For example, you may feel like it is a pleasure to help others through your work. You may feel positively about your colleagues or your ability to contribute to the work setting or even the greater good of society. burnout. And most people have an idea of what this is, but from the research, it's an element of compassion fatigue. It's associated with feelings of hopelessness and difficulties in dealing with work or doing your job effectively. They can be more gradual, and they may reflect the feeling that your efforts don't make a difference, or it can be associated with a very high workload or a non-supportive work environment. And then lastly, secondary traumatic stress. So this is about your work-related secondary exposure to extremely or traumatically stressful events. If you are exposed to other traumatic events as a result of your work, such as providing care to people who have sustained emotional or physical injuries, or presenting or representing people who have experienced those things, this is secondary exposure. The symptoms of this may be more rapid. They mirror a bit more closely what you may see or think about with PTSD. It may include things like being afraid, having difficulty sleeping, or having images of the upsetting event pop into your mind. So just think about if you are experiencing these things now, or if there have been times in the past where you recognize some of these symptoms or issues. So now we'll get into secondary traumatic stress a bit more. So secondary traumatic stress can impact how you think. And I'll pause here to actually say, with both burnout and STS, it can come on in such a way that you don't quite catch it on the front end. And because you are carrying heavy stuff so often, it may pile in a way that you don't recognize it until you're already having some symptoms. And I can share with you all that after my first consultation on a death penalty case, and it was in Florida, so I had to travel and was kind of out of my normal routine there too, and was down there for, I think, 3 to 5 days. And, you know, I'm a mental health professional. I trained as a psychiatrist. I have 3 board certifications, but I came back that weekend and just felt so depleted and was having such a hard time getting going, and was starting to wonder, like, is something wrong? Am I depressed? Do I need to make an appointment? And then thought about the fact that I was literally spending hours and hours with a man who could have been sentenced to death and testifying in this very high stakes situation, and that I had reason, right, to need to recharge, but it just didn't occur to me right off the bat that is what was necessary. And so understanding that there's definitely going to be some overlap between these symptoms and things like depression and anxiety, but also understanding that when you can tie it to something that has recently happened, or when you take a step back and you think about recent stressors, that can help you understand if it's more one thing or the other. So secondary traumatic stress can impact how you think. So things like lowered concentration, apathy, rigid thinking, perfectionism, or preoccupation with the distressing or the horrifying event. It can impact how you feel. So things like guilt, anger, numbness, sadness, or helplessness. How you operate, so you may find yourself withdrawing. And sometimes it may be that if you have a great deal of pride in your professional identity, that withdrawal happens more on the personal side of things. I've definitely had patients who were high achieving professionals for whom work was going to be the very last thing to go, right? Everything else was going to go before work did. But sometimes people have this idea, you know, I'm fine as long as I'm getting through my workload, and that's not necessarily true. Sleep problems, and those sleep problems can look like being unable to fall asleep and wind down. It can also look like using sleep as an escape when feelings or emotions become overwhelming. So it becomes a form of avoidance. Appetite changes, which can go up or go down. You also may find yourself emotionally eating, as they say, so more carbs and sugar than is usual. Hypervigilance, so feeling kind of jumpy or on edge and having that elevated startle response. And then how your body functions. And sometimes, you know, if the mental health stuff sounds a little woo-woo, people respond to this idea, which is, you know, definitely one that the research demonstrates, is stress's impact on your physical well-being. So things like increased heart rate, blood pressure, difficulty breathing, muscle and joint pain, impaired ability to fight illness, and worsening of medical problems that you already have, or maybe things start to develop, like GI upset and things like that. And sometimes that can be a signal that people start to pay attention to. And for most of us, there's this certainly a connection between your mental and your emotional stress and your body, how it's stored, where it's stored, and sometimes that can be the signal for us. And so things like exercise and sleep are really important in keeping that in mind. But I would say, even if you don't recognize any of these other symptoms, if you are noticing changes in how your body's working as you've taken on a new job or a new role or new responsibilities or a new case that's really high profile or maybe really stressful, don't just talk that up to getting older or something like that. Consider that it could be stress that is driving it or exacerbating it. And we also see that in attorneys, there's an increased risk for substance use disorder, depression, anxiety, relationship conflict as a whole. But if you're having STS as well, eventually that could affect work performance too. So in the professional role that you're in, right, we know that it is a job that not a whole lot of people can relate to. The pressures and the considerations are unique. And so when we're thinking about what's protective from secondary traumatic stress or from burnout, or for any of those diagnosable mental health conditions that you're at higher risk for, we as human beings are wired for belonging. Now, some of the things that you are hearing from your clients, you obviously can't repeat to other people. You have to keep in confidence, but there are ways that you can connect with each other, support each other, validate each other, that aren't just nice to do, but are really necessary for you to do. And so events like this, things that put you in the room, whether it's virtually or physically with your colleagues, are really important for your mental well-being. And there are ways, right, that the nature of your work can be isolating, though, from people who can't relate to that, and many cannot. You're held to a higher standard than most people in most professions. And there may be concerns about how candor may be interpreted by people who are part of your system, by the society, and just yourself and the standards that you hold yourself to. And, for most jobs, a bad day doesn't have the implications that a bad day may have for you, right? You're grappling with decisions that impact children's safety, that may impact liberty, that influence life trajectories, that may keep family units together or help contribute to their dissolution. And that is a lot. And sometimes when you do a lot all the time, you don't sit back and think about it. But it's important that you keep that in mind, because if you don't, you risk bearing that without having a corresponding corrective, deliberate action to help release some of that stress and to help ease that burden. And you all, right, are high achieving folks who have climbed your various ladders and obtained this, terminal degree of your JD. And so I'm just presuming you're all overachievers. And we know it's a thin line between the pursuit of excellence and perfectionism, between constructive criticism and demoralizing dialogue, between having internal locus of control and owning things, which we know helps people move through life, but sometimes, especially when you're dealing with families and children who have so many different things working against them, there's the piece we can control and there's a lot that we can't. And sometimes that owning things can hurt us in those situations. the utilization of intellect and reliance on rationalization. So because you're smart and you can figure things out and you have very advanced language skills, you can talk yourself through things, and some things you have to feel yourself through. But when you're used to being able to talk yourself through, sometimes pivoting or shifting to the things that are more feelings-based can be difficult. And then reaching for goals versus just overextending yourself. So I just want to spend one slide on substance use versus substance use disorder. I don't know if it's as much of an issue with folks who works with kids in families as it is with other attorneys. I won't make any assumptions, but we do know as a whole, the law profession does see an disproportionate amount of alcohol use disorder and substance use disorder. But often at these events where you are connecting with one another, where you are getting that validation and finding that sense of community, alcohol is part of it. So some warning signs, and if you are second guessing or on the fence about any of these that I go through, then that is definitely something to take seriously. Not if you're 100% convinced, but if you're even a little bit concerned. So if you find that your use of substances is increasing over time, whether that is frequency or how much you're using to get the same effect, if there's any instances where you're using it in what could be a hazardous or a harmful situation, or if the people around you, and really absolutely anyone around you, has made some sort of comment or expressed concern about your use of substances, because often people will have seen things for some time before they say anything, or there may be multiple people that have seen something, but it takes that one to say it. So whenever you get that kind of feedback, it's something you definitely want to take seriously. So as you consider these things, I would ask you to think about and check in with yourself. What is pushing you toward or away from mental health? And it could be, right, that you don't have any sort of mental health diagnoses, but there are things that you have as part of your routine that aren't pushing you toward health that you could tweak some, right, to help get you even further on that continuum. And where are you, right? Are you feeling like you are full of energy, like you are ready to go to work the next day? Or are you feeling as if you're coming from a depleted place? And what I find is that most people know what works for them. But again, just want to give you these reminders. So connection and validation, having a sense of purpose. Sleep is one of those things that, it's not sexy and it can get passed over, and it sounds really basic, but it is huge in terms of your mental well-being. And the recommendation is at least 7 hours, and it's something absolutely to be protected. Movement. I didn't use the word exercise because sometimes people have a aversive reaction to the exercise word, but really even just taking a walk, we know has benefits for people. So maybe in the afternoon, instead of drinking the third cup of coffee at 3, you take a walk outside and take that phone meeting. That doesn't necessarily need to be a Zoom call as you're walking. Support. And then diet, so avoiding things like high processed foods and those sorts of things. And again, I know this sounds really basic, but all of these things are tremendously protective for you. And not to say that you still may not have symptoms or things like that if you have these things in place, but it'll certainly be helpful in even helping you address things if and when they do come up. And it may be, right, that what works for you is very different than what works for your colleague. So I'm someone who loves to travel. I love to work out. I love to read novels. My niece and nephew are the loves of my life. And so I FaceTime with them pretty regularly and actually go visit them in Florida once a month. That is my plan. That's what works for me. And I find that most people know what works for them. It's just a matter of whether they've decided to prioritize it, right? Have you decided that you're going to block off your schedule for your vacations? Have you decided you're going to put your phone on airplane mode at a certain time and stop checking your email because it's going to be there tomorrow, right? It's not that you don't know what you need to do, you just haven't decided to prioritize it. And so as you're thinking about putting protection of your mental well-being on par with how you approach anything else that is of importance to you, you want to think about how you plan to do it, right? So there's the saying, if you fail to plan, you're planning to fail. So treating your mental well-being like, I don't want to say a job because that has a certain connotation to it, but giving it that same level of deliberate thinking and planning. So having SMART goals, telling people what you're doing, blocking off time and honoring that you're blocking off that time, and setting boundaries and keeping them. So when to seek professional help. So sometimes it can be that you're still functioning, you're still getting the job done. As I said, for a lot of you, the job may be the very last thing to go. What you may notice is, even though you're still getting through the day, it feels as if it's taking an extraordinary amount of effort to do that. So it's really taking everything you have out of you. So people who see you from 9 to 5 wouldn't know, but you get home and you crash. If there are feelings of hopelessness, worthlessness, and most certainly if there are feelings of suicidality, those are all indicators that it may be time not only to reach out to your natural supports, because you always want to do that, but it may be also time to get some professional help on your team. So of course, with therapy, you have counselors, psychologists, psychiatrists. With coaching, these are folks who are more going to think about like optimization, more so than kind of trying to treat or deal with symptoms of illness. And when it comes to medication, psychiatrists, primary care providers, and NPs are often going to be the ones who take care of that. And most psychiatric medications are prescribed by PCPs rather than by psychiatrists. I will say that when it comes to issues of diagnosable mental illness, or maybe even just STS or burnout, medication is really a blunt instrument that can be helpful for some people, but therapy is going to be able to be much more tailored to you as an individual, and will give you skills, hopefully, that you can use throughout the lifetime, whereas medication doesn't have that same staying power. Now, if someone is suicidal, if they're really having impairment in their functioning, what we know is that the two of them together work faster. We know the effects of therapy last for longer. And those are always decisions that you want to make with your healthcare providers, but just wanted to put a plug there, and you may not have expected this from a psychiatrist, but therapy is what you need as your baseline when these things come up in the vast majority of circumstances. And then thinking about what you're experiencing, how you may be feeling. And sometimes we are trying to do yoga and meditate out of a toxic situation, right? Sometimes your manager is not supportive and they're gaslighting you, and no amount of adaptive coping is going to make up for that, right? So the question, and I have to give credit to Alta Stewart, who is a mentor of mine, a psychiatrist based in Tennessee, who says, is it burnout or is it arson? So at a certain point, sometimes you have to take a step back and ask about the office you're in, the person you're directly reporting to, the people you're around, and considering how much of this is really external to you. That is not a coping issue, but is an issue that is only solved by you being in another place one of my favorite business books is What You Do is Who You Are. And one of the things that the author says is people don't leave jobs, they leave managers. And I think that's absolutely true. So always considering that as well. And Edward Deming said a bad system will beat a good person every time. And I don't need to tell you all about the difficulties of navigating the legal system, especially on behalf of marginalized populations. So you already have that as your baseline, right? So it's really important that the kind of micro environment you're in your office is one where you feel supported and heard and validated. So the survey is in the chat. I will not have you do it for the sake of time because I would love to have your comments and your questions, but I hope that you all will take that link and complete it and do some reflection on where you fall. And so, of course, this was a very quick talk about these topics, but it's always important to come back to them, to be curious about yourself and about how you're doing and to give yourself space to do that. And this is something that is always, right, going to be part of your journey in this field. And it may be that you have a certain level of support and you have a set of coping mechanisms that works when you have a caseload that's relatively small, but as your practice grows, as your responsibility grows, as your profile grows, the level of support and your coping mechanisms are going to have to shift and adapt as well. And just keeping in mind, right, that there is the reality of adulting, as the young people say, and what will come with that at certain periods and windows. And I find this really more so with my, I would say, younger millennial clients, but everything is in pathology, right? There isn't a need to pathologize everything. There will be times where you're feeling that stress more. The question is this becoming routine? Is this becoming part of your life? Is this impacting sort of who you are and how you see yourself and how you see the world? And then we need to think more about, intervention or changing things up. And again, just this idea of connecting to purpose, right? Because when you're doing hard work, it's critically important to keep that front and center. So I just love this quote. Says, "It is not true that people stop pursuing dreams because they grow old. They grow old because they stop pursuing dreams." So just keeping in mind all of the ways that you are already serving the families that you work with. But there are all kinds of different ways that you can serve them too. And sometimes it's a matter of taking a step back, reconsidering, and thinking about other ways that your work could be done if a place that you're in or the tasks that are in front of you don't feel like a good fit for you at this stage in life. And with that, I will pause. And actually, I see that I might have missed some stuff in the chat. So let me look at these. So someone commented on the arson issue. And it's one we definitely are up against in healthcare too. I don't see any questions in the chat. Thank you all for your feedback, but certainly welcome any questions or comments at this time.
Hi,
Well,
I have one question. I've been in the work for a long time. My name's Leslie, and I've been a parent for maybe 15 or 16 years. And one of the things I think that the work has really impacted for me is parenting. What I have permission for parenting. Sometimes I feel haunted by a lot of my work around decisions around parenting and very kind of escalated. And I wondered if you had any suggestions around that.
Wow, huge question. And disclaimer, I'm just an auntie, I'm not a mom, but I do sit with a lot of professional mothers. And, one of the things that I think is important to say from the top is that most kids have secure attachment. So odds are the kids are fine and they're securely attached to you. And these worst case scenarios that you see play out are not applying to like you or your children. So that's, I think, something important to keep in mind. The other thing that I'll say from that standpoint is, I think there's certainly a way that, and I'll speak from a little bit from personal experience too, the way that we train, we have to do training with adults before we do training with kids. And I found that working with kids all the time was taxing in another kind of way, because you're sitting with them as they're young people and you're seeing them go through this versus an adult telling you about what happened in the past. And so that experience is certainly not unique to you. And I think that there's a way that attorneys who work with youth have to be even more diligent because of how sensitive you are to what your clients are experiencing, and to, they just tug at your heartstrings in a different way. And I can only imagine that that's, amplified for mothers. And I've heard people talk about how that's impacted their work. One thing that I would say is that boundary issue, I think, is even more important for you and for your family. I have a lot of moms with young children that work with me actually on the forensic side. And I'm like, why are you texting me at 7 o'clock? Stop, go away. Like I said, that stuff will be there. And what you find, and they actually have done some studies around people in high demand jobs and parenting and how they feel in terms of like mommy guilt and that sort of thing. And what they found is that if you have the sense that you are fully present with your children during the time you spend with them, that is what's most important. So it's not the total amount of hours, it's the degree of your presence and the quality of your presence during that time. And that is also what has value for the kids as well. And hello to the cat.
All right, I think if there are no more questions, I want to thank you, Dr. Vinson, for being here in this presentation. I think, focusing on our mental health and wellness, we can't do this work without being mentally healthy ourselves. And, I think this is just a really important topic for all of us. And it's been a rough last couple of years. So I do thank you for being here. I just want to thank you for your presentation today. And with that, I will turn it over to Mr. Berlon.
Thanks, Jill. I appreciate that. My apologies. Can't turn on the video screen, but I want to say thank you to Dr. Benson and Director Bruce for the presentation. I do want to add to Dr. Benson's presentation by saying, as a reminder, that the State Bar actually has an employee assistance program. And if you feel like you're in crisis or you just need someone to reach out to, there is a number, and I will probably ask that be in our next publication and part of the transcript of this. Don't hesitate to reach out. As it relates to professionally, feel free to reach out to anyone in the executive committee to see how we can best help you in this, not only what's been presented today, but in any part of our field. We look forward to supporting you. And again, a reminder, if you're interested in serving on the executive committee, please reach out to the new officers between now and June so they can know of your interest. I appreciate it so much. And at this time, I'm going to close our meeting. Thank you so much and have a good week.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.